Hey, everybody, and welcome to Thursday night. Thursday Night Live here again. This is John Skiba. I'm a consumer protection attorney and bankruptcy attorney in the state of Arizona. And I'm also the founder of the Consumer Warrior YouTube channel, where each and every week on Thursday nights, we meet and talk about all things debt related, serious debt problems. We don't want to talk about just the little stuff. We talk about things where it is officially almost out of control. That's the kind of stuff we'd like to deal with on a daily basis, particularly debt collection lawsuits. Coughing already. Debt collection lawsuits, bankruptcies, Fair Debt Collection Practices Act type things. We do this each and every week. And the way that I like to do it is if you're on YouTube, in the chat section, you can go ahead and post a question. I'll throw it up on the screen and we can discuss it. You'll see that I posted there a link to some of the tutorials and templates that I put together related to debt collection lawsuits specifically. You can check those out. But otherwise, throw your question up there, and I'll do my best to get through as many of the questions as I can here in the next 30 minutes or so. My weekly disclaimer: even though I am a licensed attorney in the state of Arizona, I cannot provide legal advice. I don't know your situation specifically. We've never met. And so I highly, highly, highly recommend you contact an attorney in the state where you live. And so if you're in the state of Arizona, I'm here to help you out. I do consultations and take on cases for people who are in the state of Arizona. You can get my contact information. Let me switch that so you get my actual phone number. I work at the law firm of Jackson White. That's why you're seeing that logo there, and it has our phone number and our website where you can learn more about my law practice. So with all that, man, we already have the shoot. We got people here. Al from Tucson, thank you very much. You're here. You've been here so much lately in supporting the channel. I sincerely appreciate that. So, all right. Let's jump in. Angie. Angie's here early with a great question. John, I have court on Tuesday, going to be studying your videos this weekend. Any advice? I'm scared. One thing I would say is it's normal to be nervous. Attorneys are nervous. Even the attorneys have been doing it a long time. It's public speaking, and there's a lot riding on it. If you're defending yourself, there could be thousands of dollars riding upon your ability to do it. Actually, probably just made you more nervous right there. So one of the things, and I don't know if it's too late, but one thing I recommend you do if you're going to court, if you're actually going to attend court, which post-COVID is more rare, but is to actually try to go down to the courthouse and watch the judge or see if there's any hearings. Court proceedings are public, and people can just go and sit in the back of the courtroom and watch. And as a young attorney, I remember the first time the partner that I was working with took me to court with him. I sat in the back and kind of probably arrogantly, because I didn't know what I didn't know, but I thought I could do this. This doesn't look that hard. But it also gives you some insight into the way the judge does things, where you're supposed to sit. That was always one of my biggest things as a new attorney, is like, which side of the room do I sit on? Most courts, it'll have plaintiff and defendant. If it doesn't, if it has a jury box, like where the jury sits, then the plaintiff sits closest to the jury, and the defendant, you would sit far away from the jury box. So kind of little free tip there as far as where you sit. But yeah, just kind of going over it. And I always say to be prepared. Write down your notes. You don't have to read it word for word, but put together an outline. That's how I do it. The points that I want to make sure that I get, and then I practice it. Even here at my office, I shut the door and I practice because the more you say it, the more comfortable and the more kind of muscle memory you'll have when it comes time to actually deliver it. And don't lose focus of what your goal is here, what your role is. As the defendant, you don't have to disprove anything. The plaintiff has to prove, that you had the account, what the balance was. They have to show if it was transferred to them, if they were a debt buyer. And you don't have to disprove that. You can kind of just sit back and punch holes in their case. So Angie, I wish you luck on that. And you're telling me you do have to attend in person in Iowa. So if it's possible, tomorrow is a holiday. Tomorrow, in a lot of areas, so the courts might be closed. But if not, it might be good to just kind of sneak down and then take a look at that. You also ask, if you lose, could I request a payment plan to avoid a possible garnishment? If you lose a case, and get this, a lot of people wonder, can I just go to the court and ask for a payment plan? The court is there to determine whether you're liable or not for the debt. And so people are kind of surprised that, if you go to the court and say, hey, judge, I can pay $25 a month or whatever, the courts don't even get involved in that kind of process. Well, so the judge will either grant a judgment or they won't. They'll grant a defense verdict. And if they grant a judgment, then the creditor can go to wage garnishment. But usually in most jurisdictions, they're going to have to file an application for a writ of garnishment, and then they're going to have to serve that on your employer. That process takes a little bit of time. So if the judgment gets entered against you, what I often recommend is reaching out to the creditor directly and trying to figure out some kind of payment plan or settlement at that point. So, all right, let's see here. Let's see what Mary has to say. I have 2 houses in my name, but one belongs to my son and his wife. Could I file for bankruptcy? Obviously you can file for bankruptcy, but I know that your question is, am I going to lose the house if I file for bankruptcy? So in a Chapter 7, the idea behind a Chapter 7 is you're going to get rid of like your unsecured debts, credit cards, medical bills, personal loans, all those things go away completely. But the trade-off is if you have any non-exempt assets, the court, or usually the bankruptcy trustee, can seize the asset, sell it, and give the money to your creditors. So in most jurisdictions, you have a homestead exemption that protects your home up to a certain amount of equity in the home. So for example, in Arizona right now, the homestead exemption protects up to $250,000 of equity. Just went up on January 1st of 2022, which is awesome. However, the housing prices are still out of control. And so a lot of people even have more than $250,000 of equity in their property. But if you have 2 houses and your name is on both of them, the one thing you'd want to look at is how much equity you have in each property. And you look at equity by looking at the value of the home, subtract any liens or mortgages that you have against it, and then that leftover balance is your equity. Also, there could be an issue because if your son's a part owner of one of the homes, then he may be able to claim a homestead exemption in it, and it wouldn't be a big issue. Definitely an issue. I wouldn't file bankruptcy without talking to an attorney and finding out the specifics as far as how the property's held. But it is possible. From what you're telling me here, I think it could still be possible. And you're finding, I'm saying that they're both paid off. So 100%, if you've got paid off properties, then the equity is really easy. It's just the value of the property is to have someone look at that, see how they're titled, and then see what the homestead exemption is in your particular state. All right, let's see here. Veronica says, I received a motion for summary judgment on March 17th, went to file my response today, and was told the moving party has not filed it with the court. Should I still file a response or just wait? This happens more than you would think. I don't know what it is with some collection law firms. If they're just sending them out at the same time, they're sending one to the court, sending one to you, and then it takes a while for them to process. I've seen it where just like I'll get served with a copy of a motion for summary judgment. I'll draft the whole response. I'll go to file, and the clerk will say the same thing. They're like, we don't even have a motion for you to respond to. Technically, you don't have to, if it's not filed with the court, it's not legitimate. You don't have to respond to it. I would maybe just double and maybe triple check that the clerk just hasn't missed over it, that it hasn't been filed. You could even reach out to the creditor's attorney and say, hey, I know you gave me this, but you didn't ever file with the court, and see what their response is. Because that 30 days, usually most jurisdictions will give you a 30-day window to respond to it. It's going to depend on when you actually, when it was filed with the court. That's a big deal. So I would dig a little deeper to make sure it wasn't. If they didn't file with the court, you don't need to respond to it because there's nothing to respond to. The judge isn't going to rule on anything at that point. So, all right, let's see here. Angie, thank you. I don't know if the world's better off because of people like me, but I appreciate the comment. So, all right, let's see here. Man, did I already get through everything? Maybe I went through there a little too quick. But yeah, so when it comes to debt collectors, sometimes you see that they'll do things like that, where things just don't get filed properly. But I also have seen it where courts don't process things quickly. So it could be something if they're just mailing it in, the court gets it, it sits there in a pile for a few days. If there's any type of holidays, anything like that, it may just not get processed for a while. So you may want to be really careful there. Well, if there's any other questions, please go ahead and put them in the chat section. I've had a couple scenarios this week here in my office that has just driven home the point. When it comes to debt, and particularly serious debt problems, it's super important that you take action on it. This throughout my career, I've seen this happen where people meet with me in a consultation, and then I don't hear from them. They don't ever call back or anything, and that's fine. You know, not everybody has to hire me or anything, but it's something where, and then they call back 6 months later, and they've been hit with a wage garnishment. Dealing with these things early on, you're going to get, and dealing with them head on. One of the most videos on my YouTube channel that I get the most pushback from is the one where I say, don't avoid the process server. Just accept the complaint and someone just deal with it head on. People are like, oh, that's horrible, you know, to say that on the internet. Half of the battle is just showing up to this. And if you're able to deal with it head on, you're not going to get surprised with some kind of wage garnishment. So I just seen it too many times where people leave it be and no one actually, you don't take any action. And then there, you know, it's going to be, there's big problems related to that. So, all right, let's see here. Angie had one other follow-up saying, is there a chance that the junk debt buyer won't show up? You know, when I first started taking these cases, probably about 12, 13 years ago, they didn't show up often. And part of it, though, is because here in Arizona, there's not a ton of us that do this defense work. There's literally a handful of us that take these cases with any consistency. And so they kind of got used to being a little bit lazy with them, I think, the prosecutions or the creditors' attorneys. It's rare when I see that they just don't show up. But if they don't, you should ask for dismissal. And I always remind judges, if the judges are like, well, we'll just continue it, I always say, look, if I didn't show, my guess is that the defense would have a judgment against them immediately. And I one time even had a judge tell me, yeah, you're right. And he granted the dismissal. He dismissed it without prejudice, though, and that was an issue. So, all right. Hey, and Angie, too, you're saying that wage garnishment is a big problem. And that's why it is good to get in front of it. Like I was saying, to make sure you take action. If you get the payment plan in place, they're not going to garnish your wages. If a wage garnishment was to come into play, you could then look at a bankruptcy option. And bankruptcy can stop a wage garnishment almost immediately. So, all right, let's see what Gerard has to say. I got a dismissal with prejudice from portfolio lawsuit, but I filed a request for hearing for the settlement agreement. They filed a request for substitution of counsel. Okay, so I don't know if there was a specific question there, but that's great if you got a dismissal with prejudice. I mean, that's what you're going for. You know, if they just drop the ball, and maybe if they're switching out attorneys, that was part of the reason why. So, all right. Jeffrey says, does the debt collector need to contact you if they're going to garnish wages? So they do have to notify you, but like in Arizona, they don't have to notify you before it happens. So what happens in Arizona when it comes to wage garnishment is your employer is going to get let me back up. What they're going to do, they file an application for a writ of garnishment. That they file that with the court. That does not have to be mailed directly to you at the time of filing. And then once the court signs off on it, they send it to your employer, and then your employer has to do that. And then your employer is supposed to provide you with a copy. So the first you hear about it is when your employer already knows, and then your employer has to start withholding wages, at least in Arizona, on the very next paycheck. So garnishment is very state specific. So if you're not in Arizona, you need to look it up. And the garnishment laws are always needlessly complicated, but that's something that you definitely need to look for your local state, how they handle it. Surprisingly, some states, if you don't have wage garnishment, I've always said, you know, Texas doesn't have wage garnishment. So if you live in Texas, it may be, you know, whatever, taken care of there. So, all right, let's see here. Angie asking, is there a chance they won't allow a payment plan? You know, if a judgment gets entered, the creditor doesn't have to accept a payment plan. I always say their goal is to get money. If you're offering money, there's got to be some kind of middle ground that can be reached, particularly on a payment plan. Usually what I try to do if there's a payment plan is do something where make sure that no interest is accruing on it, because particularly if you're paying a low dollar amount payment plan, is something that will I've seen clients where there's this huge interest rate that's accruing on the thing, and they're making $25 a month, and then 5 years later they owe more than they did when they started. So, all right, let's see here. All right, I think that's the questions for tonight. Well, we could end early tonight, but Angie, good luck with your case. Good luck with your prep over the week. Kind of a bummer that you have to do that over holiday weekend, but I'm sure you're going to do great. Again, if you want to, I have some of the tutorials and templates. I pin them up at the top there with the Consumer Warrior templates. You can click on there and check those out. And I've fallen behind on my videos each and every week. I need to get a couple more videos out. I'm working on some right now, but I appreciate everybody checking in tonight, and we'll catch you next week.